Hey, for any of you new, I'm John Miller. I'm the founding attorney of Rock Solid Law and Title, finishing out celebrating 30 years of independent practice, beginning here in beautiful, what is a gorgeous day, beautiful Ponte Vedra Beach, Florida, and now back in Ponte Vedra Beach, Florida. After some years, the practice was located in Atlantic Beach and Jacksonville Beach. Mostly Jacksonville Beach for a while, and delighted to be back in our new offices. If you haven't checked them out, we invite you to come do so at some time in the near future. So the firm does three things. We do close, you heard the title part, we close real estate, both commercial and residential, professionally and on time. We represent owners of small businesses with every contract in action from inception to transition. And the transition phase of small business ownership is what led me in the 1990s into the concentration that we're going to talk about today, and the focus that that we now have, which is a primary focus of the firm, on estate planning. So there's what we do and who we are. Our firm plans on the basis of your values and what's important to you. But I have found over time that one of the quests of our firm is to help our clients to pay only mandatory taxes and not any voluntary ones. We're going to talk a little bit about that this morning. So welcome, partners, to the Last Chance Tax Saloon. I thought that was a pretty creative little phrase. We really are on last chance for 2021. The good news for you is that neither I nor anyone I know has a crystal ball, and we don't know what's going to happen over the next now 29 days of December and whether a new tax bill will go into effect. We do suspect, or we know, that the day that the president signs it, there will be significant changes, and there will be opportunities that are lost if planning hasn't been done before that day. We don't know, other than that one fact, which we're going to be going over, what else may be retroactive, potentially to January 1st, 2022. That is my best guess from all the reading I've done. Again, it is just an educated guess. Each of you can make your own, and it has as much validity as mine, assuming you've done some reading on the subject. There are things that people can do between now and the end of the year. Obviously, we would have preferred to have a head start, maybe starting back in October, but we have capacity to serve a few clients if there is a need. Most of the subjects are going to be talking about opportunities available for people with significant net worth. However, in the 25 or so years that I have been practicing law in the estate planning field, I've regularly found and am of the opinion that strategies that apply to the wealthy often also apply to those at the next level. So regardless of what you've accumulated to this point or what you might accumulate in the future, knowledge of these ideas, concepts, opportunities could certainly behoove you. Perhaps there are some of you on the call today that will think, oh my goodness, we better jump quickly. I have a lot of material I'm going to cover in the next probably 25 minutes due to my time constraints and the material to be covered today. I'm not going to take live questions on this particular webinar, which I know is a departure. Should you have questions, I will ask you to send them to questions, really creative, right? Questions at rocksolidlaw.com. And that will come to a member of my team who will get it to me, and we will get you answered. So you get an answer to your question. This is the penultimate, love that word, webinar of 2021. We're going to do one more, and rather than our newly adopted 2-week cadence, we're going to do it next week simply because of the holidays. That will also be on the subject of estate planning and will be specifically regarding the documents that are used in the estate planning field, the essential documents, the names of which you ought to know. If you know me, you know that I believe that the documents themselves are probably the least important aspect of estate planning. The planning is what really matters. Yeah, you can click a button, get online, and find a perhaps decent, perhaps not document out there on the internet. But the real thing that you want to consider in your document preparation is the planning that went into it, so they actually reflect the values of you and your family. So we're going to talk about that one next Thursday at the same time, 9:00 a.m. It'll probably be the last time you listen to the Commodores in 2021. So this one's going to require some reading, so you get John with reading glasses. At my age, I'm glad that's one of the few things that I need. So listen, the proposed new estate tax law exemptions, which currently range between 3.5 and 5 million per spouse, inflation adjusted, and at a tax rate between 40 and 55% on the excess. So what we're seeing right now, following the enactment of the Trump administration, is the greatest exemption that there ever has been in the history of our country. It's currently at 11.7 million. We're going to talk more about that. So if for the significantly wealthy people making a transfer now, and we're helping a client with that right now, before that goes away, can save 40% of tax on the difference between 11.7 and whatever it ends up being. We think it's going to go back to pre-2016 numbers, somewhere in the $3.5 to $5 million per individual range. So the Democrats are proposing funding the $3.5 trillion Build Back Better Act agenda. The bill includes several important tax provisions that would considerably restrict certain commonly used wealth transfer strategies. A little bit more on that proposal later. The strategies, other than a simple gift of the $11.7 million gift and estate tax exclusion, could be impacted by the new House rules before the end of the year. So for the super wealthy, getting the use of that gift and estate tax exclusion, gifting as much of that 11.7 per spouse as possible, is the strategy. A lot of us don't have the opportunity to enact that strategy because we don't happen to have $11.7 million sitting around to give away to the next generation or to a charity of our choice, or through other tax planning devices. More on that later. The overarching strategy is opportunity shifting to future generations by moving business opportunities and upside profits to younger generation family members. Okay. So which strategies should we favor? In short, we already talked about it. Large gifts to irrevocable and intentionally defective grantor trusts, which is sometimes referred to as IGTs, that take advantage of valuation discounts when appropriate. All three would be substantially limited under the proposed House rules, the proposed law that is working its way through Congress now. So for those that own an interest in a small business, it is an excellent time to get something done before the end of the year, but which includes a business valuation. And with what did I say? We have 29 days to go. We need to get started if there are small business owners who want to take advantage of this opportunity. And again, for a lot of us, 11.7 is pie in the sky, but that doesn't mean that we shouldn't take advantage of whatever opportunity we have, and particularly for small, closely held business. We already said large gifts for those that can afford them. Under the current law, the gift and estate tax exclusion is, one more time, 11.7 million per person. So for a couple, that's still at 23.4 million, which can be moved. The House proposal would have that amount to about 6, as we said before, maybe as low as 3.5. We just don't know what's going to come out of the compromise. And I don't know, and nobody knows. Disclaimer one more time. with inflation adjustment effective, we believe, in 2022. Obviously, we'll be back on here talking more about it as we learn more. If enacted, the new lower exclusion would be further reduced by any prior taxable gifts. Okay, so if you've already used your exclusion gifts, you can't double up on them between now and the end of the year. You just have the opportunity for a lot higher ceiling now than you will almost certainly later. I said no crystal ball, but I think everybody believes the 11.7 is coming down. All right, if enacted, the new lower exclusion would be further reduced by any prior taxable gifts. I just said that. I'm sorry, guys. That means an individual who uses 6 million of her exclusion prior to 22 would have zero exclusion remaining next year. Got it? So to take advantage of the current elevated exclusion amount, an individual would have to give away more than 6 million prior to the end of this year. Anybody who's in that situation needs to see us quick. Ideally, she would give away the full 11.7 if she can safely afford to do so. For this reason, married couples should not necessarily split the gift. Instead, consider using one spouse's exclusion in its entirety first to take full advantage of that spouse's enhanced exclusion as it now stands, right? So say there's somebody that has the ability to give away 15 million, they would want one spouse to do the full 11.7 because the other one, that last 3 plus, is going to be available to be given away in the future anyway. We can quickly assess how much an individual or couple safely can afford to give away given their own unique circumstances without adversely affecting lifestyle spending and other personal financial goals. If we're going to try to make that assessment, we need to jump on it almost, well, beyond immediately, to tell you the truth. To maximize the benefit, make those gifts to the UGTs I talked about earlier, and under current laws, gifts to a properly structured IGT, did I misspeak? IGT, including the post-transfer growth of those assets, avoid estate tax upon the grantor's death. This is an opportunity. In the meantime, the grantor, as deemed owner of the IGT's assets for income tax purposes under the grantor trust rules, pays income taxes each year on behalf of the trust and its beneficiaries. Given the powerful nature of this estate planning strategy, it's not unusual for an IGT to accumulate 25 to 50% more wealth at the grantor's death than a comparable trust that bears its own income tax burden during the grantor's lifetime. So it has the opportunity to grow significantly during your lifetime, going to the next generation. Yet the House proposal would effectively eliminate this path by including IGT's assets in the grantor's estate for estate tax purposes. The new law is scheduled to take effect on the date of enactment. The date of enactment, essentially when the president signs the bill. So all bets are off after whenever President Biden signs that bill. So while taxpayers needn't contend with a potential decrease to the gift and estate tax exclusion until next year, the loss of IGTs as a planning strategy could occur prior to year end. IGTs established and funded prior to the date of enactment, before he signs, would still avoid inclusion upon the grantor's death, provided no further gifts are made. Families who want to take advantage of wealth transfer planning using IGTs may have weeks, not months, to complete those transfers. Importantly, the permissible benefits of an IGT include the grantor's spouse. Beneficiaries includes the spouse. Such a trust often is referred to as a spousal lifetime access trust, a SLAT. You've heard of those. This approach This approach may prove valuable for married couples who are uncomfortable giving away 11.7 million in assets to a trust solely for the benefit of the grantor's descendants. In other words, you can use your spouse instead of your kids. Keep it in your generation. A slat provides a path to bring wealth back into the marital balance sheet, if needed, by having assets distributed to the grantor's spouse, right? So if you had to distribute, you could have it distributed to your spouse and you'd have access to those funds. I love the title of the next subject, and I wish I had written it. I didn't. Cramming 15 pounds of groceries into an 11.7 pound bag. That's great. Should those who can afford to give away more than the 11.7 before the end of 2021, do so? It would require paying gift tax at a rate of 40% on any excess. And although paying gift tax may be beneficial in certain cases, most families seek to avoid it. Under current law, those families have options. An installment sale. First, in addition to an $11.7 million seed gift, the grantor may sell assets up to 9 times that amount, or more than $100 million, according to most practitioners, me included, to an IGT in exchange for a low-interest promissory note. In return, the IGT is typically required to pay the grantor just annual interest-only note during the note term, with repayment of principal postponed until maturity, which can be determined by the parties. Further, in today's landscape, the seller, i.e. the grantor, does not recognize capital gain upon such a sale. That's because, as the deemed owner of the IGT's assets for income tax purposes, she is deemed to have sold the assets to herself. The House proposal would eliminate this non-recognition, effective as of the date of enactment, treating the transaction as a taxable sale or exchange. Big deal. That's a big deal. However, an installment sale completed prior to that date would not be subject to those parameters, thus the need for speed. Valuation discount, right? This is where the valuation comes in. Second, prior to giving or selling assets to an IGT, a transfer first may contribute those assets to an entity, such as a limited liability company, an LLC, in exchange for ownership interests, and then give or sell non-voting interests to an IGT. Using an LLC or other entity in this fashion has many potential non-tax benefits like asset protection, including consolidation of asset management and economies of scale, especially when investing in non-traditional asset classes. In addition, a non-voting interest in an LLC or other entity should not be worth a proportionate share of the liquidation value of the assets held by the entity. Why? The holder of such an interest typically cannot sell that interest to a third party without the permission of the entity's manager, and cannot compel a distribution from or otherwise control the entity. Given these constraints, a discount in the value of the interest may result due to the lack of marketability and lack of control. These are valuation discounts. It's a little bit technical, but it is something that is done regularly. In fact, it's not unusual to see a 20 to 30% reduction below the liquidation value of the holder's proportionate share of the entity's assets. This is another way a lawyer can help. I have just come across somebody who years ago had a partner die and bought out the spouse at 100% value, where there really should have been a valuation discount because the company was worth significantly less due to that partner's non-involvement, no future involvement in the company. We could have helped had we been involved at that point in time. Right now, the IRS often contests these discounts, but in many cases, taxpayers have been successful defending it in court. Now, not every case is contested and not every case goes to court. So you want to be reasonable in your valuation so that the IRS does not feel the need to contest. My guess is so many of these things are going to be happening across the country at this point in time that the IRS is not going to have the opportunity to contest a substantial portion of them. But again, that's just an educated guess. Again, the House proposal would eliminate valuation discounts for non-business assets effective as of the date of enactment. Taxpayers who have been considering wealth transfer strategies, especially those involving big gifts and or sales of discounted assets to IGTs, should act swiftly. That's the whole purpose of the last chance saloon. Strategies other than a simple gift of that 11.7 million and a gift and estate tax exclusion to one or more individuals and taxable trusts could be impacted by the new House rules before the end of the year. And as we said previously, when the president signs the bill. So 3 strategies I'm going to go over. I knew this was a lot of material, and I'm going to go past the 30-minute mark, I believe, today. I'll try to wrap it up for you guys, but this is, again, a lot of material. Income reduction strategies. As a result of the recent evolution of tax reform, few effective and legal planning techniques remain by which taxpayers anticipating a spike in income can reduce their potential income tax liability for the taxable year of the spike. So if you had an income spike, you would consider offshore captive insurance companies and pension regimes, tax credit, oil and gas and similar syndications, domestic qualified retirement plans, and charitable-based strategies, among others. 2, estate tax reduction and elimination strategies. This is partly what we've been talking about. Under the current federal transfer tax regime, transfers of property by owners to their children or grandchildren during life by gift are immediately subject to gift tax and are later subject to death, at death, to estate tax and possibly the generation skipping tax, which for time conservation, I'm going to call the GST from here forward. The federal transfer tax system currently includes an integration of the gift and estate tax, while the GST is separate and possibly additive tax. The current rate of gift and estate tax is a flat 40%. Number 3, common elements of wealth transfer planning. Many of the advanced planning techniques pursued by wealthy individuals and families involve the creation and use of closely held family businesses or investment vehicles, such as S corporations. I mentioned LLCs. We could go with family limited partnerships and family limited liability companies. Transfers occurring during the transfer's lifetime by gift or upon the transfer's death by bequest or inheritance outright to trust. Grantor deemed owner trust, GDOTs, or, as we mentioned before, irrevocable, defective, irrevocable trust, which are called IDITs. Beneficiary deemed owner trusts. Other strategies are GRATs, GRITs, CUPERTs, beyond the split interest, charitable trusts described above. Advanced planners commonly use non-charitable, split interest, irrevocable trusts in their planning. So again, if there is a strategy which may apply to you and your family, we need to get started. And if it involves an entity, it needs to be valued. And we have an amazing appraisal firm that we work regularly with who may have the capacity to take another matter or two in this year. Obviously, we want to transfer assets to the trust quickly. And the dynastic trust in particular is the centerpiece of the advanced planning work. We love working with families through dynastic trusts. It's beautiful to see families taking care of one another. And as I often state, holding together the family tree for generations to come. But these must be established and funded. That means title needs to be transferred into them before the president signs the legislation. Dynasty trusts are always sound multi-generational planning techniques, but the challenges are drafting in the necessary flexibility for the family, directed trusts, trustees, trust protectors, decanting provisions, etc., and funding them efficiently given the available exemption amounts and GST exemption limitations. Maintaining a zero inclusion ratio for the Dynasty Trust is imperative. Probably, I'm rounding what's the bend in a horse race called, so I'm heading to home. Probably the only safe strategy is a single spousal lifetime access trust, a SLAT, with a second following in 2022, if the tax reform does not undermine the efficacy of grant or trust. We just don't know. Everyone's making a rush to get this done, and it will be a golden opportunity lost if you don't act now. The urgency and potential value to the planning would suggest we immediately start. All work needs to be completed by December 31st. So, for instance, what we would need, it's going to take a cooperative effort to do it this quickly. What we would need would be any existing, for you to provide, any existing estate planning related documents, all legal entities which you are an owner of, and any subsidiary, parent and subsidiary entities, copy of all life insurance policies and the ledgers for each with the owner and beneficiary in writing, updated personal financial statement, like one you'd bring to a bank with true or slightly higher than what you might think values are. It's easier to plan for more than less. And again, must finalize by December 31st. So my point there is, it's going to take your cooperation. This is not something you could just dump on us or anybody and hope that it gets done by the end of the year. This will take a concerted effort over the next 3 weeks. So two things in closing, and I've done well. It's 9:29. If you're interested in a complimentary 1 hour to discuss this in private, please let us know by no later than Wednesday of next week. I would really like to meet with you next week if this is something you or one of your contacts, clients, referrals are interested in doing. Need to jump on it now. We have a little bit of bandwidth in the firm. We have the expertise in our circuit to take care of all of this for you, but it's going to be a push to get it done. And again, if you don't, we don't really know what's going to happen in 2022. We may have another opportunity, but it may be an opportunity lost forever. And then finally, anybody who's on the call, thank you for joining us. And I do have a summary of the House Ways and Means Committee report. If that would interest any of you to have a copy, merely email me at questions@rocksolidlaw.com, questions@rocksolidlaw.com, and we will get that report right out to you. I know I covered a lot quickly. There's a lot of uncertainty this year. There often is, but we've had a significant change in our federal government affecting taxes this year, and we think there'll be even more change next year. So we want to be on top of it, predicting as well as we can to protect our clients as best we can, again, so that they pay only mandatory taxes and no voluntary taxes. Thank you. I say there are two tax codes in this country. One is for the informed and one is for the uninformed. I believe those of you that joined us or are watching the video of this are better informed after the last 30 minutes together. Thank you so much for joining me. Again, if there are any questions, send them to questions@rocksolidlaw.com. I'm John Miller, and I founded this firm 30 years ago. It is our joy to serve the community of Northeast Florida and to try to help our clients in the best manner possible plan for the future of their families. Happy holidays all. And again, one more estate planning webinar next week, 9 a.m. A little nuts and boltsy. It's going to be going over the documents typically incorporated in a basic revocable living trust plan. Have a great week, and I'll see you then.